Hi, everyone. I'm Jessica Eaves Mathews with Leverage Legal Group. If you're a founder, I want you to picture this. You're scrolling online late at night, maybe you're on Amazon or Etsy, Instagram, TikTok, and suddenly you see it, your brand name, or something that looks like it or sounds almost exactly like it, but it's not you and it's not your brand. Someone else is using a name that feels way too close for comfort. Your heart sinks, you're angry, you're protective, and your first instinct is probably, they're infringing on me and I need to shut this down. Before you do anything else, I want you to pause because the very first question in trademark enforcement is not how do I stop them? The first question is, what rights do I actually have? And this is where a lot of founders get tripped up and where well-intended enforcement can actually backfire. The truth is that not every brand name is trademarkable, and not everyone who feels copied actually owns enforceable rights. Step one, always, is figuring out whether your mark qualifies for trademark protection and whether you might actually be infringing on someone else. Let's unpack that. Trademark rights in the US are largely based on use, not just registration. And this is where the concept of date of first use becomes critical. Your date of first use is the date you first used your mark in commerce, meaning when customers actually encountered it in connection with your goods or services. And generally, it's across state lines. Now, if you have a website, that qualifies. Here's something that surprises a lot of founders. A common law trademark, meaning an unregistered mark, but one that's being used, can sometimes have stronger rights than even a registered trademark. If the common law user started using that mark first and later decides to apply for registration. If you adopted your brand name last year, but someone else has been using a similar name in the same industry for 5 years, they may actually have seen your rights, even if they never registered and even if they're geographically very far from you in the US. This means before you accuse someone of infringement, you need to know whether you are actually the junior user. This analysis matters a lot, because sending a cease and desist letter when you don't have priority rights can expose you to risk, including a countersuit or a demand that you stop using your own brand. Next, the issue is whether your mark is even protectable. Some marks are strong, some marks are weak, and some aren't protectable at all. If your brand name is merely descriptive of what you sell, for example, like fast shipping vitamins or downtown yoga studio, trademark law may not give you exclusive rights right away. Descriptive marks generally need to acquire what's called distinctiveness, meaning customers have to come to associate that descriptive name specifically with you and your offerings, and not just a general concept of that type of product or service. And that takes time. And in many cases, at least according to the Trademark Act and the USPTO, 5 years of time or more of consistent use. And if you're using it for that long, it can help establish that level of distinctiveness that would give you the ability to protect even a descriptive mark. But before that point, your enforcement options can be very limited. If you haven't been using your mark for very long, or if it's highly descriptive, you may not yet be in a position to stop others from using similar language. And that can be frustrating to hear, but it's much better to know early than spending money enforcing rights you don't actually have or opening yourself up to a countersuit for infringement that would actually force you to have to respond or potentially even rebrand. And this is why it's so important to work with a trademark lawyer at the outset. A good trademark lawyer is going to analyze your rights, your risks, and your position in the marketplace before any action is taken. And they can help you answer questions like, do you have priority? Is your mark distinctive enough to enforce? Are you actually at risk of infringing on somebody else's rights? Should you adjust your branding strategy now to avoid bigger problems later? Once you've done that analysis, the next critical step then is trademark registration. If your mark is protectable and you have priority rights, then getting a federal trademark application on file should usually happen before you start enforcing your rights. I mean, you have to get the trademark application on file before you start enforcing your rights. Registration strengthens your position dramatically. It gives you nationwide presumptions, access to platform enforcement tools, and clearer leverage in disputes. Trying to enforce a brand without registration or without understanding your priority is like trying to build a house without checking the foundation. Now, once you've confirmed that you have enforceable rights, that's when enforcement strategy comes into play. And this is where most founders think enforcement begins, but in reality, it's step 3 or 4, not step 1. Most trademark disputes also never go to court, and most enforcement, when done correctly, is quiet and efficient. I worked with a small consumer brand that found a competitor using a confusingly similar name on Etsy and Instagram. Same type of products, same customer base. But before doing anything, we did the work I talked about a few minutes ago. We confirmed her priority, evaluated the strength of the mark, and made sure enforcement wouldn't boomerang back on her. And only then did we take action. The result was simple. The listings came down, the other party backed off, there was no lawsuit, no public drama, and it wasn't a huge expense for my client. And that is what strategic enforcement looks like. Founders with limited budgets also have access to tools that many people overlook. Platforms like Amazon, Etsy, eBay, and social media sites have trademark enforcement systems built in. These are far more effective when you have a registered trademark and a clear legal position. It's important to do that initial analysis that I described previously. And these systems are unforgiving. So if your complaint is weak, inaccurate, or overly aggressive, it can be rejected or even used against you. This is why firing off angry emails, posting public accusations, or copying cease and desist templates from the internet is so risky. I've seen founders accidentally weaken their own trademark rights by saying the wrong thing at the wrong time. And this is where having a trademark lawyer really earns its value. If you're listening to this and wondering what to do next, here are your practical action steps. First, get clarity on your rights, understand your date of first use, your priority, and whether your mark is distinctive enough to enforce. Second, if your mark qualifies, get a federal trademark application on file immediately. Third, set up basic monitoring so you know when potential issues arise. You can do this through Google Alerts, for example. And finally, before you engage in any enforcement activities, get advice. Trademark enforcement isn't about picking fights. It's about protecting the trust that you've built and avoiding mistakes that are far more expensive to fix later. Knowing your rights is the foundation. Everything else comes after. In this episode, we talked about what to do when someone appears to be copying your brand and why the very first step is understanding what rights you actually have before you try to enforce anything. But there's a closely related issue that many founders don't realize is connected. Sometimes the problem isn't just a competitor's using a similar name. Sometimes it's counterfeit products using your actual trademark, and those are entering the US without your knowledge. And that creates a different kind of risk. Customer confusion, quality complaints, damaged reviews, loss of trust or reputation, even when you did everything right with your brand. In the next episode, I'm going to walk you through how counterfeit goods get into the US, what tools founders have to stop fake products, both at the border and on platforms like Amazon and Etsy, and how small and mid-sized brands can fight counterfeiting without a massive legal budget. If you sell physical products, that conversation is critical, and I will see you in that next episode.